We offered her 3 years and kept that open. No, ma'am, 3 years in the prison, which is down 17 years off of the 20 years. And we offered that to her and kept the offer open until right before she chose to go to a jury. You asked, did we show her mercy? We offered her a plea bargain. That's what we offer in cases where we weigh.
It's State Attorney Angela Corey, who was a prosecutor in the George Zimmerman case, explaining her decision to offer a plea to Marissa Alexander. She did not take that plea. She ended up she's now doing 20 years in prison. Still with me are Jelani Cobb from the University of Connecticut, civil rights attorney Barry Scheck. Jelani, when you see these two cases side by side, and again, there's different facts to each, there's different circumstances, obviously, but side by side in the same jurisdiction, what do you see?
The thing that I find most striking about this is that she brought charges, she brought these charges against Miss Alexander voluntarily. She didn't have to,
right.
But they were forced, essentially, by political pressures and ongoing mass demonstrations to bring the charges against Mr. Zimmerman. And so what it says to me is that she found this case more palatable. Despite the fact that there's exculpatory evidence here, there is a track record of domestic violence. The the estranged husband did say that he had been violent toward her and two previous women, describing punching his ex-wife in the mouth. There are the instances of the restraining orders. And so this gives you a reason to say this person's life is in jeopardy.
And I think part of what made the verdict so hard to swallow on Saturday night in the broad context is the fact that the way the criminal justice system works is that we all got to see this trial, which is great, and the system working, and reasonable doubt, and a very vigorous defense. It was, I think, a very well done defense in the context of putting on a defense, right? But that most of the American criminal justice system looks absolutely nothing like that. Right. I mean, you work in this day in, day out. It looks nothing like that.
Nothing like it. And the overcharging, though, by Angela Corey in this Marissa Alexander case is so troubling. Given the fact that the abusive husband, admittedly abusive husband, at one point recants his testimony, then flips back at the time of the trial. The son had recanted. She's giving these statements that, oh, she went into the garage and came back, and therefore she's not entitled to stand your ground. When she went into the garage, she couldn't get out. She was looking for her keys, and that's why she brought the gun back. I mean, it just is the kind of case that screams out for the exercise of prosecutorial discretion. She should have never been put into that position in the first place, where she's running the risk of 20 years.
And I thought it was interesting, this idea that, well, we offered the plea and she didn't take it. That, pleaing is what the criminal justice system does, and that's actually what these officers are prepared to do. Here's the share of criminal cases going to trial has dropped sharply in the 1980s with tougher sentencing laws. In 1980, over 20% of criminal cases went to trial. In 2010, it's less than 5%. So what we're seeing is a system that now can dangle much harsher possible penalties for people. The much harsher penalty is the thing that scares people into pleading. And we have a system that is only equipped to plead people out. If everyone went to trial, the entire thing, right? The entire thing would collapse in on itself.
Right. And what we effectively do is curtail the right to a trial by jury of your peers, because you have two options in a draconian sentence or a possibly terrible plea bargain.
Right.
And so this is what we have. We wind up with situations like Marissa Alexander, which we should say the issue is not solely her, but what happens to the next person who's innocent and knows about this case? They take a plea bargain for something that they really shouldn't have ever been charged.
People will say about the criminal justice system, they'll be like, well, all these people are guilty. That's, and you find the odd person who's innocent with your Innocence Project, and you find DNA. But does the system do a good job of divining, of essentially exercising any discretion? I mean, is it mindful? Is it just in who it prosecutes and who it does?
Well, it's become almost mindless because we have such an expansion. Just take misdemeanors. People go to criminal court all the time on cases where they can't afford lawyers. The lawyers are overburdened themselves. They don't have enough resources. If you want to come back to court 5, 6, 7 times and lose your job, well, you have that option. Right. Or you can take this misdemeanor plea with all the collateral consequences. There are more people pleading guilty to misdemeanors who are innocent. It's beyond imagination.
And once you plead a misdemeanor, you are marked by the system. You are now sorted into the pile of people that are suspicious from there on. Jelani Cobb from the University of Connecticut, civil rights attorney Barry Scheck. Thank you, gentlemen, both. That is all in for this evening. The Rachel Maddow